Welcome to the Tailor Law Podcast, where we provide trusted legal guidance for families navigating challenging times. I'm your host, Deepa Taylor. Today we're diving into a topic that affects countless families across Ontario: debunking common family law myths. Whether you're considering separation, navigating a divorce, or simply want to understand your rights better, this episode is for you. Family law can be confusing, especially with the abundance of misinformation circulating through social media, friends, and well-meaning family members. Today, we're setting the record straight on some of the most persistent myths in Ontario's family law system. Let's start with a common one. If I move out of the matrimonial home, I lose my rights to it. This is a widespread belief, but it's simply not true. In Ontario, the matrimonial home holds a unique status under the Family Law Act. Regardless of whose name is on the title, both spouses have an equal right to possess the home until it's legally divided. Leaving the home doesn't forfeit your entitlement to its value. However, decisions about leaving should be carefully considered, especially if children are involved. If you're in a situation where staying in the home is unsafe, prioritize your safety and seek legal advice to protect your rights. Another myth we often hear is common law couples have the same rights as married couples. This is false. In Ontario, common law relationships do not automatically entitle partners to property division upon separation. While married spouses have a right to equalization of net family property, common law partners must make specific claims, like resulting trust or unjust enrichment, to seek a share in property. If you're in a common law relationship, a cohabitation agreement can help clarify property rights and prevent disputes down the road. Now here's a popular misconception: paying child support gives me automatic access to my children. Child support and parenting time are two separate legal matters. Paying support doesn't guarantee visitation or custody rights. Access to children is determined by what's in their best interest, not financial contributions. If you're facing challenges in seeing your children, it's crucial to seek legal help to establish a formal parenting plan or custody arrangement. Let's talk about pensions, a topic that often surprises people. Many believe my pension is protected in a divorce. In reality, pensions are considered part of the marital assets and are subject to division. Just like a home or investments, the value accumulated in a pension during the marriage must be factored into the division of property. This can be complex, so obtaining a pension valuation and legal advice is essential to ensure a fair division. Another widespread myth is, if I own the house before marriage, my spouse can't claim it. This is partly true but overlooks important details. In Ontario, the value of property owned before marriage is excluded from equalization, except for the matrimonial home. If the home you shared with your spouse was brought into the marriage, its entire value, from the date of marriage to the date of separation, is included in the division of property. Planning ahead with a marriage contract can protect premarital assets. One of the most emotionally charged misconceptions is, mothers always get custody of the children. This is outdated thinking. Ontario family law focuses on the best interests of the child, not the gender of the parent. Courts consider various factors, including the child's needs, each parent's ability to provide care, and the child's relationship with each parent. Both mothers and fathers have equal opportunities to seek custody and access. Another misconception involves spousal support. Spousal support is guaranteed after divorce. This isn't always the case. Spousal support depends on several factors, including the length of the marriage, each spouse's financial situation, and roles during the marriage. Some spouses may be entitled to support, while others may not. The goal is to address economic disadvantages arising from the marriage or its breakdown. Let's also clear up the belief that verbal agreements are enough during a separation. While it may seem easier to agree on terms without legal documents, verbal agreements are risky. They aren't legally binding and can lead to misunderstandings. It's always advisable to have a formal separation agreement drafted with legal guidance to protect both parties and avoid future disputes. Finally, there's the myth that lawyers always make divorces more complicated and expensive. At Tailor Law, we believe the opposite. A good family lawyer simplifies the process, protects your rights, and helps you reach fair resolutions efficiently. Legal representation can prevent costly mistakes and ensure that your agreement is enforceable. Navigating family law is challenging, but understanding your rights and responsibilities can make all the difference. If you're facing separation, divorce, or any family law issue in Ontario, Tailor Law is here to help. Visit tailorlaw.com to schedule a consultation with one of our experienced family lawyers. We're committed to guiding you through every step with clarity and compassion. Thank you for tuning in to this episode of the Tailor Law Podcast. If you found this information helpful, please subscribe, share this episode, and leave us a review. Until next time, take care and remember that informed decisions are empowered decisions. For personalized legal advice, visit us at tailorlaw.com or call us today. We're here to help you navigate family law with confidence.